Welcome back to the Dispute.a podcast. I'm Paul. This is episode 2. In the first episode, we established that the pre-legal space exists and that most disputes are resolved inside it. This episode is about the boundary of that space. When is a dispute still pre-legal, and when has it crossed into territory where only formal proceedings will resolve it? Knowing which side of the boundary you're on is one of the most important early judgments in any dispute. Get it wrong in one direction, and you waste months negotiating with a counterparty who is never going to move. Get it wrong in the other direction, and you escalate to a courtroom, a matter that could have been settled for less, faster. The boundary is not where most people think. Most people assume the boundary is the moment a lawyer gets involved. It isn't. Lawyers operate extensively in the pre-legal space. A lawyer drafting a demand letter, advising on a negotiating position, or reviewing a settlement is doing pre-legal work. Others assume the boundary is the moment things get adversarial. It isn't that either. Pre-legal disputes can be intensely adversarial. The parties can dislike each other thoroughly and still be in the pre-legal stage. The boundary is procedural. A dispute is pre-legal until a formal claim is filed with a court or a binding tribunal. Once that claim is filed, the matter is in the legal stage. The decision maker is no longer the parties, it's the court. The timetable is no longer the parties, it's the courts. The outcome is no longer something the parties control, it's something they argue for and then receive. That's the formal boundary. But there's a more useful practical version of the question. The practical question is resolution still in the parties' hands. The practical version of the boundary question is this. Is the resolution of this dispute still something the parties can determine between themselves, or has it moved beyond their control? A dispute is practically pre-legal when the parties still hold the resolution. They can still negotiate. They can still agree. They can still trade positions and reach an outcome neither loves but both accept. The matter is alive in their hands. A dispute has practically crossed the boundary when the parties no longer hold the resolution. This happens for several reasons, and they're worth knowing. Reason 1. The counterparty will only respond to a filed claim. Some counterparties and some developers fall into this category, have a settled policy of not engaging seriously until a claim is actually filed. They treat pre-legal approaches as noise. They have the resources to absorb pre-legal pressure indefinitely. For them, the only signal that triggers genuine engagement is a filed claim with a case number. If you're dealing with a counterparty like this, the pre-legal space is narrower than usual. You can attempt it, but you should attempt it, knowing that the realistic trigger for movement is the credible, imminent prospect of filing or the filing itself. A good liaison process reads this early. It doesn't spend 6 months in pre-legal negotiation with a counterparty whose entire posture is to wait for a claim. It identifies the posture and adjusts. Reason 2. A deadline is closing. Every legal claim has a limitation period, a window after which the claim can no longer be brought. The periods vary by the type of claim and the law that governs it. If the limitation period on your claim is approaching, the pre-legal space is closing, whether you like it or not. Continuing to negotiate while the clock runs down is dangerous. If the limitation period expires mid-negotiation, your leverage collapses entirely. You no longer have a credible claim to file, and the counterparty knows it. The discipline here is to know your limitation period from the start and to treat it as a hard boundary. Pre-legal work has to be completed or the claim filed to preserve it before that period expires. Reason 3. The dispute needs a remedy only a court can give. Some remedies are only available from a court. An injunction to stop something happening. A binding order compelling specific performance. A formal declaration of rights that third parties will be bound by. The enforcement of a claim against assets. If what you actually need is one of these, the pre-legal space can only take you so far. You can use it to try to achieve the practical equivalent by agreement, but if agreement fails, the remedy itself requires the court. Reason 4. Trust has fully collapsed. Pre-legal resolution requires a minimum of working trust, not friendship, but enough mutual reliability that an agreement, once reached, will be honored. Where that minimum is gone, where the counterparty has broken prior agreements or shown they will not honor what they sign, the pre-legal space stops being useful. An agreement you can't rely on isn't a resolution. In those cases, the value of a court outcome is precisely that it's enforceable without the counterparty's cooperation. The reverse error. Escalating too early. Everything so far has been about recognizing when a dispute has crossed the boundary. The reverse error is just as costly, escalating to formal proceedings, a dispute that was still firmly pre-legal. This happens when a disputant is angry, frightened, or has been advised by someone whose incentives favor escalation. They file a claim on a matter that a structured pre-legal process would likely have resolved for less money, in less time, with less damage. Once a claim is filed, some of the pre-legal flexibility is lost. The matter is now on the court's timetable. Costs have started accumulating in earnest. The counterparty's posture often hardens because they're now defending a filed claim rather than discussing a complaint. The boundary is not where the lawyers arrive, it is where the resolution leaves the parties' hands. How to read your own position. So how do you tell which side of the boundary you're on? A few honest questions. Does the counterparty engage at all with pre-legal approaches, or do they ignore everything short of a filed claim? How much time is left on your limitation period? Do you need a remedy only a court can give, or do you essentially need money or a contract variation that the parties could agree between themselves? Is there enough working trust that an agreement would actually be honored? Are you considering escalation because the dispute genuinely requires it, or because you're frustrated and escalation feels like action? A structured pre-legal process runs these questions deliberately at the start of a matter. It produces a clear read: this is still pre-legal, and here is the plan, or this has crossed the boundary, and here is why. What to take from this episode? The formal boundary is the filing of a claim. The practical boundary is whether the resolution is still in the parties' hands. A dispute has practically crossed the boundary when the counterparty only responds to filed claim. The reverse error: escalating too early. Everything so far has been about recognizing when a dispute has crossed the boundary. The reverse error is just as costly: escalating to formal proceedings, a dispute that was still firmly pre-legal. This happens when a disputant is angry, frightened, or has been advised by someone whose incentives favor escalation. They file a claim on a matter that a structured pre-legal process would likely have resolved for less money, in less time, with less damage.